Well, it's sad but real. There is people get married and then people get divorced. And so the question that's been proposed is, well, what happens when estate planning and divorce collide? Well, here in California, we have at least a minimum of a 6 month time period between the filing of a divorce petition and the actual conclusion where you're now legally divorced. Not separated, but you're now divorced, no longer husband and wife or spouses. So if you go through the entire divorce process and you come out on the other end and you are legally divorced, you're no longer spouses, any place where your former spouse was listed either as a beneficiary or as a fiduciary is basically disregarded. That spouse is deemed to have predeceased you, and therefore they cannot inherit the assets passing through the trust as a primary beneficiary, and they cannot act as your fiduciary for making healthcare decisions for you, etc., which kind of makes sense. However, what happens though during that 6 month mandatory minimum period if there's an incapacity or death that happens during that time period? Well, what happens to the assets then? Well, that's a little bit different because during that time period, you may be legally separated, but yet you're also still legally married, and so you're still spouses. You still got community property assets, and then the spouses still have an interest in those assets of the then deceased spouse. So all the preferred positions are still unaffected by the simple petition for filing a divorce. So the first thing you want to do is you got to have an update to your estate plan, but you got some challenges there because when someone files that divorce, there is a immediate and temporary restraining order that prevents you from modifying trust assets and from moving and funding a new trust, which kind of makes sense because you wouldn't want one of the spouses to file for a divorce and the other one take all the assets and move them somewhere else and then to change the assets and change the planning. It kind of would defeat the purpose. So here what you can do, however, is you can revoke your existing trust because trusts comprise typically of the community property assets as well as the separate property of the contributing spouse. So if you simply revoke the trust, which you can do during that 6 month period, it simply just puts those assets back in the position that they were in before they were put in the trust. So basically the community assets, or at least one half, goes back to the revoking spouse and all the separate property goes back to the separate spouse. So here you did not have a change or modification of the trust terms, nor did you have a new transfer or funding. You just basically put yourself back in the position that you were in before you funded the trust by doing the revocation. And you don't need both spouses to consent on that. One spouse can revoke at least their portion of the trust, which again bring half the community property and the separate property back into their name. And then what you could do is you can then immediately create a new estate plan. Now you create a new trust with your new beneficiaries, new trustees, and you would create a new will. Now, here you got to be very careful because you're not going to fund that new trust. You're not going to put the assets in that new trust. What you're going to do is you're going to create a trust that's going to be empty, but it's going to have all the provisions in there that you want, and you're going to have a new will that makes reference to that other trust because now if you pass away, those assets will be transferred via your will, and the will then pour it into your new trust, and that is acceptable as well. Another important thing to be aware of, if you have joint tenancy assets, sometimes you may have joint bank accounts. Even though you may be spouses, you still can have assets held in joint tenancy, whether it's property or bank accounts, and joint tenancy has a right of survivorship. So if one spouse dies, then it automatically, by operation of law, will then vest 100% in the surviving spouse. And again, that may be inconsistent with your overall intent as part of your divorce proceedings. Another important thing is to update beneficiary forms to your life insurance policies, and but you got to be careful there. Also, is you have to worry about you can make changes, but it only affects your 1/2 interest in the community assets. Remember, your spouse, when you paid the premiums on that insurance or when you contributed to your retirement plan, they had a 1/2 buy-in in the community property. So even though you may be able to make modifications only to half of it, you got to be aware of what the impact is on the other half. Let's take a look here. What else is important to know? Oh yeah, and all the powers of attorney. So here you have no problem. There's no question that upon the filing a divorce, you may want to change who you're making your medical decisions for you. For most people, during the planning process, they normally put their spouse as number one, but if all of a sudden you file for divorce, you may not want your now soon-to-be ex-spouse making decisions for you and wanting to pull the plug. They may do that a little prematurely, and you wouldn't want them managing the finances. So you may want to put somebody else in there to make medical decisions for you, someone else to be able to to manage your assets during the time of dependency of the finalization of the divorce, and also to represent you if you're unable to represent yourself in the divorce proceedings. So I guess an important takeaway from all this is that whenever you have an existing estate plan and you're filing for divorce, there are some things that you need to do, and you need to act quickly. Some things can be done as part of a pre-divorce planning, but once that petition is filed, there is a temporary restraining order which locks the hands of a lot of people and really minimizes what you can and cannot do. So the important takeaway here is that you need to coordinate this both with your estate planning attorney and your family law attorney. They must work together. Some things can be done and some things cannot be done. We don't want to be in violation of any court temporary restraining orders in the process of trying to update your estate plan. So again, there's some things that can be done, but they have to be done properly and have to be coordinated with both your family counselor as well as your estate planning attorney. So my name is Brad Barth. I'm a partner here at Barth Calderon. So if you find yourself in a divorce or know someone in a divorce or maybe pending or thinking about divorce or currently in divorce, you need to update your estate plan and make some changes. Let me know, give me a call. And like I said, we're Barth Calderon. We plan today for all your tomorrows. Thank you for your attention. Bye-bye.